There is a precise moment when a predatory corporation realizes they haven't trapped a helpless victim, but have instead walked willingly into a legal slaughterhouse. For 3 years, the executives at Vanguard Energy watched Arthur Vance. They watched his grazing lands wither under a staged drought, they watched his bank notices pile up on the dashboard of a battered 1998 Ford F-150, and they smiled. They thought he was a broken, dirt-poor rancher holding on to a worthless patch of West Texas dust. They thought today's public mineral rights hearing was a mere formality, a final, crushing rubber stamp to strip his land. They were wrong. Arthur Vance wasn't broke, he was waiting. The atmosphere inside the county courthouse's auxiliary legal chamber was thick with the scent of stale air conditioning, cheap floor wax, and unearned corporate confidence. On the left side of the polished mahogany barrier sat the Vanguard team. There were 4 of them, 2 senior corporate litigators from a powerhouse Houston firm, a junior analyst holding a sleek leather folio, and Marcus Vance, Arthur's estranged nephew turned Vanguard landman, wearing a tailored charcoal suit that cost more than Arthur's monthly livestock feed bill. They exuded the calm, sanitized arrogance of men who used the legal system as a bulldozer. To them, the law was not about justice, it was an exercise in financial exhaustion. They had spent 18 months burying Arthur in motions, delaying hearings, and running up his perceived legal costs, waiting for the inevitable white flag. On the right side sat Arthur. He sat alone at the defense table, wearing a faded canvas jacket with frayed cuffs and a pair of work boots stained with limestone dust. He didn't have a legal team. He didn't even have a laptop. In front of him sat a single, battered cardboard accordion file held together by a thick rubber band. To anyone walking into the room, the contrast was stark, deliberate, and pathetic. Marcus wouldn't even look his uncle in the eye, preferring instead to tap rhythmically on his tablet, reviewing the final lease acquisition forms that would grant Vanguard total subsurface access to the 12,000-acre Blackwood Ranch. The administrative law judge, a sharp-eyed woman named Clara Higgins, took her seat at the bench. She glanced down at the docket, her expression neutral but tinged with the slight weariness of a public servant accustomed to seeing independent landowners swallowed whole by corporate energy cartels. Case number 44B, Judge Higgins announced, her voice echoing slightly in the Spartan room. In the matter of Vanguard Energy versus the estate of Arthur Vance, regarding petition for forced pooling and subsurface mineral extraction rights under Section 102 of the State Natural Resources Code. Let the record show the petitioner is represented by counsel. Mr. Vance appears pro se. Vanguard's lead attorney, a man named Henderson whose hair was silvered to perfection, stood up smoothly. He didn't just speak, he projected. Thank you, Your Honor. The issue before the board today is straightforward. Vanguard Energy holds the valid subsurface oil and gas leases for 90% of the contiguous drilling block in the Alpine Shale Formation. Mr. Vance owns the surface rights and a tiny fraction of the legacy mineral interests on the remaining 10%. Under the state's forced pooling statutes, we have offered Mr. Vance fair market value based on independent geological assessments. He has repeatedly rejected these offers, acting as an arbitrary holdout. We are asking the board to grant an administrative order to compel integration so that state resources are not wasted by a single, insolvent property owner. Henderson paused, casting a brief, performative glance of pity toward Arthur. We take no pleasure in this, Your Honor. We understand Mr. Vance's emotional attachment to the land. But the financial reality is absolute. The Blackwood Ranch is heavily leveraged. Local tax liens have already been filed against the property. Mr. Vance simply does not possess the capital to develop these resources himself, nor can he afford to block production that benefits the entire county's tax base. We have entered our certified financial analysis of the property into evidence as Exhibit A. Judge Higgins looked over her glasses at Arthur. Mr. Vance, do you have an opening statement, or would you like to respond to the petitioner's evidence regarding the financial insolvency of your estate? Arthur didn't stand up immediately. He reached down, slowly peeled the rubber band off the cardboard file, and pulled out a stack of tightly bound documents. When he finally stood, the floorboards creaked beneath his boots. He didn't look at the judge, he looked directly at his nephew, Marcus, whose tapping fingers suddenly stopped. Your Honor, Arthur began, his voice surprisingly deep, steady, and devoid of the folksy panic Henderson had clearly anticipated. Mr. Henderson is entirely correct about one thing. The Blackwood Ranch is deep in debt. I haven't paid my property taxes in 14 months, and the local co-op cut off my commercial credit line last Tuesday. If you look at my bank accounts, I am, by every standard of Wall Street, completely broke. A faint, smug ripple of satisfaction passed between the Vanguard lawyers. Henderson began to sit back down, preparing to write a victory note to his regional VP. But, Arthur continued, his voice dropping an octave, cutting through the silence of the room like a cold front. There is a fundamental difference between a man who has no money, and a man who has chosen not to cash his checks. Vanguard Energy is operating under the assumption that they are trying to buy an unproven lease from a failing rancher. What they don't realize is that I don't need to sell them a lease. Because for the last 90 days, Vanguard has already been drilling on my land. And they aren't here today to acquire rights, they're here to cover up a felony. The room temperature seemed to drop instantly. Marcus went pale, his hand hovering over his tablet, while Henderson froze mid-motion, his polished smile instantly vanishing. The silence in the hearing room was no longer polite, it was suffocating. Judge Higgins paused, her pen hovering a fraction of an inch above her legal pad. She slowly lowered it, her sharp gaze shifting from Arthur's weathered face to the Vanguard defense table, where Henderson was already on his feet, his poised demeanor replaced by aggressive posture. "Your Honor, I must object," Henderson barked, his voice cutting through the room with practiced indignation. "This is a highly inflammatory, completely unsubstantiated accusation designed solely to delay these proceedings. Vanguard Energy is a publicly traded corporation with an unblemished regulatory compliance record. We have not broken ground on any surface location within the boundaries of the Blackwood Ranch. Our nearest active well pad, Alpine Alpha, is situated exactly a quarter-mile outside Mr. Vance's property line on the neighboring Henderson estate. To accuse this company of a felony without a shred of evidence is a sanctionable offense. I am aware of where your surface pad is, Mr. Henderson," Arthur said calmly, not looking up from his stack of documents. He slid a high-resolution, color-printed map across the mahogany barrier toward the court clerk. "And I am not accusing you of surface trespass. I am accusing you of subsurface conversion, the unlawful extraction of minerals from a non-leased estate via deviated horizontal drilling. You didn't cross my fences with bulldozers. You crossed my boundary lines 2 miles beneath the earth." Marcus, the young landman, felt a cold bead of sweat trace down his collar. He knew the engineering data for Alpine Alpha. He knew exactly what they had done. He leaned over to whisper urgently into the lead attorney's ear, but Henderson brushed him off, fixing his eyes on the judge. "Your Honor, this is absurd," Henderson insisted, though his voice lacked its previous melodic certainty. "Horizontal drilling is a highly complex, mathematically controlled engineering process. All of our wellbore trajectories are filed with the State Regulatory Commission. They are public record. Our engineers utilize state-of-the-art gyroscopic surveying tools to ensure strict adherence to our permitted drainage blocks. Mr. Vance is a cattleman, not a petroleum engineer. He is misinterpreting standard seismic or geological data. Let's look at that public record, then," Arthur countered smoothly. He pulled a second document from his accordion folder. It wasn't the photocopied, blurry mess Henderson expected. It was a certified true copy of Vanguard's own directional drilling logs, stamped by the state regulatory agency just 48 hours prior. "This is Exhibit B," Arthur announced, his voice echoing off the concrete walls. "These are the true-to-life spatial coordinates of the Alpine Alpha No. 3 horizontal wellbore. According to Vanguard's public filing, the lateral segment of this well was supposed to run strictly north to south, parallel to my eastern property line, maintaining a legal 300-foot buffer zone. But if the court turns to page 14 of the certified log, you will see the actual directional survey data point data." Arthur stepped forward, his heavy boots giving him a grounded, unshakable presence that commanded the room. On March 12, at a total measured depth of 11,200 feet, the drilling assembly encountered a highly localized, high-pressure fault line. To avoid losing the bottom hole assembly and blinding the well, he knew the engineering data for Alpine Alpha. He knew exactly what they had done. He leaned over to whisper urgently into the lead attorney's ear, but Henderson brushed him off, fixing his eyes on the judge. "Your Honor, this is absurd," Henderson insisted, though his voice lacked its previous melodic certainty. Horizontal drilling is a highly complex, mathematically controlled engineering process. All of our wellbore trajectories are filed with the State Regulatory Commission. They are public record. Our engineers utilize state-of-the-art gyroscopic surveying tools to ensure strict adherence to our permitted drainage blocks. Mr. Vance is a cattleman, not a petroleum engineer. He is misinterpreting standard seismic or geological data. Let's look at that public record, then, Arthur countered smoothly. He pulled a second document from his accordion folder. It wasn't the photocopied, blurry mess Henderson expected. It was a certified true copy of Vanguard's own directional drilling logs, stamped by the state regulatory agency just 48 hours prior. "This is Exhibit B," Arthur announced, his voice echoing off the concrete walls. "These are the true-to-life spatial coordinates of the Alpine Alpha No. 3 horizontal wellbore. According to Vanguard's public filing, the lateral segment of this well was supposed to run strictly north to south, parallel to my eastern property line, maintaining a legal 300-foot buffer zone. But if the court turns to page 14 of the certified log, you will see the actual directional survey data point data." Arthur stepped forward, his heavy boots giving him a grounded, unshakable presence that commanded the room. On March 12, at a total measured depth of 11,200 feet, the drilling assembly encountered a highly localized, high-pressure fault line. To avoid losing the bottom hole assembly and blinding the well, it is a physical intrusion. It is subsurface trespass. And the oil you have pumped out of that well for the last 2 months isn't your production. It belongs to the Blackwood estate. Marcus finally spoke up, his voice cracking slightly under the pressure. "Uncle Arthur, be reasonable. Even if the well drifted, you don't have the financial resources to litigate a subsurface trespass case. A lawsuit like that takes years. The bank is foreclosing on your ranch in 3 weeks. You can't afford to fight us." Arthur finally turned his gaze to his nephew. It wasn't a look of anger, it was a look of profound, devastating pity. "Marcus," Arthur said softly. "You always did look at the price of things without ever understanding their value. You think I didn't pay my taxes because I couldn't afford them? I didn't pay them because the moment I paid them, your company would have known I had liquid capital. I wanted you to think I was desperate. I wanted you to rush this hearing. I wanted you to stand up in a court of record and swear under oath that you hadn't touched my land." Arthur drew another document from his folder, his movements slow, deliberate, and entirely devoid of hesitation. "Because while you were waiting for me to starve, I was waiting for you to finish the well. You see, a trespasser who steals oil before a well is completed only owes the value of the crude minus the cost of drilling. But a trespasser who knowingly extracts oil after they realize they are in trespass is a bad faith converter. And a bad faith converter doesn't get to deduct the cost of drilling. You have to pay me the gross value of every single barrel you took. And according to your own production meters, that's 42,000 barrels of sweet crude." Henderson didn't look at his legal pads anymore. He didn't look at the judge. He stared fixedly at the rough-edged cardboard accordion file resting on Arthur's table as if it were a ticking explosive device. The junior analyst beside him was typing furiously on his laptop, his face drained of color as the mathematical reality of Arthur's trap began to populate his spreadsheet. "Let the record reflect," Arthur stated, his voice ringing with a calm authority that completely dominated the room, "that Vanguard Energy's daily production reports for the Alpine Alpha No. 3 well show an average extraction rate of 700 barrels of oil per day. At the current market index of $74 per barrel, that represents over $51,000 in daily gross revenue. Over 62 days, that totals $3.1 million in stolen property. And under the statutory laws of this state regarding bad faith subsurface conversion, I am not only entitled to the gross proceeds without drilling cost deductions, I am entitled to treble damages for willful concealment. This is outrageous." Henderson finally exploded, slamming his open palm onto the mahogany table. "Your Honor, this is a calculated ambush. Mr. Vance has deliberately sat on this information, allowing a multi-million-dollar infrastructure project to proceed just so he could maximize a civil penalty. This is equity in bad faith. If he knew about this deviation 2 months ago, he had a legal obligation to mitigate damages by notifying our field operations team immediately. Arthur didn't flinch. He simply reached back into his folder. I did notify them, Mr. Henderson. Or rather, I attempted to. I have here Exhibit C, a certified mail receipt, signed and dated April 2 by Marcus Vance, Vanguard's regional landman, at your corporate field office in Midland. All eyes snapped to Marcus. The young man looked as though he might physically collapse into his expensive suit. His mouth opened, but no sound came out. The letter enclosed in that packet, Arthur continued, reading directly from a carbon copy, clearly stated that my independent surface surveys indicated an anomalous seismic vibration crossing my eastern boundary. I explicitly requested that Vanguard pause lateral drilling operations on Alpine Alpha until a joint gyroscopic survey could be conducted. Marcus, what did you do with that letter? The silence stretched until Judge Higgins tapped her gavel once, a sharp, metallic sound that forced Marcus to look up. Mr. Marcus Vance, you are an officer of this court as a licensed landman. Answer your uncle's question. Did you receive and process that formal inquiry? I thought it was a nuisance claim, Marcus whispered, his voice trembling. We get dozens of them from local landowners trying to hold up drilling schedules for extra payout. I looked at our primary filed engineering trajectory, saw it was cleared on paper, and I filed it away. I didn't think it was based on real telemetry. You didn't file it away, Marcus. You shredded it, Arthur said, his voice entirely devoid of malice, carrying only the weight of cold, historical fact. But you forgot that the certified mail tracking receipt requires a digital signature uploaded directly to the Federal Postal Registry. And you forgot that your company's internal server logs track every piece of scanned correspondence. I subpoenaed those server logs through a secondary discovery motion in a parallel county matter 3 weeks ago. Your corporate IT department complied without even realizing what they were handing over. Henderson sank slowly back into his chair. The legal ground beneath his feet hadn't just shifted, it had entirely dissolved. His entire strategy had been built on the premise that Arthur Vance was a desperate, uneducated old man drowning in debt, someone who could be intimidated into signing away his ancestral rights for pennies on the dollar. He had structured his entire presentation around the narrative of a benevolent corporation trying to save an insolvent estate from its own stubbornness. Now, his star witness and regional representative had just admitted, on the record, to concealing an act of structural trespass to protect a corporate timeline. Your Honor, Henderson said, his voice dropping into a desperate, hushed tone of damage control. In light of these unexpected operational discrepancies, Vanguard Energy requests a temporary recess of 48 hours to review our internal telemetry and consult with our engineering staff. We want to ensure that any discrepancy is handled with the utmost transparency and fairness to the landowner. An adjournment? Arthur asked, turning to the judge. Your Honor, Vanguard didn't want an adjournment this morning when they were trying to force pool my ranch based on a fabricated narrative of financial ruin. They wanted an immediate order. They wanted to seize control of my subsurface assets before the sun set today. They have already entered their financial assessment of my estate into evidence. They chose this battlefield. I am simply asking that we finish the fight. Judge Higgins looked down at Henderson, her expression carved from stone. The motion for a recess is denied, Mr. Henderson. Your company brought this petition under an expedited administrative framework, asserting that time was of the essence because the landowner was financially unstable. It appears the only instability in this room is your client's adherence to property law. Mr. Vance, please continue. Arthur nodded, turning back to his accordion folder. Thank you, Your Honor. Now that we have established that Vanguard Energy is operating in bad faith, and now that we have quantified the exact scale of the subsurface conversion, we arrive at the core matter of today's hearing, the forced pooling petition. He pulled out a final, surprisingly thin document. It wasn't a corporate log or a government survey. It was an old, yellowed piece of parchment with elegant, cursive script fading at the margins, the original 1922 deed for the Blackwood Ranch. Vanguard's petition rests entirely on the claim that they own 90% of the contiguous mineral block, and that I am a minority holdout owning only 10%, Arthur explained, holding the deed up so the court could see the historical seal. But they made a catastrophic error in their title change search. They tracked the mineral assignments back to 1974, assuming the modern executive rights followed the standard split estate doctrine. But they failed to look at the original executive reservation clause instituted by my grandfather, Silas Vance, when he first consolidated this section. Arthur laid the deed on the clerk's desk. Silas Vance didn't just reserve the mineral rights. He inserted a restrictive covenant into the absolute chain of title. A covenant that states no subsurface lease on any portion of the original 12,000 acres can be validated without the unanimous consent of the surface owner, in perpetuity. Vanguard's leases with my neighbors aren't just overlapping, they are legally void because they violate the foundational covenant of the master tract. Henderson didn't stand up this time. He couldn't. His body seemed to have gone rigid, anchored to his leather chair by the sheer weight of Arthur's words. The silver-haired litigator looked down at his own manicured hands, suddenly realizing that every motion he had filed over the last 18 months hadn't been wearing Arthur down, it had been giving Arthur the time he needed to trace the title chain back to the dawn of the state's oil boom. Let me explain how a title error like this happens to a multi-billion-dollar enterprise, Arthur said, his tone conversational. Almost like a professor explaining an elementary mistake to a distracted classroom. When Vanguard decided to develop the Alpine Shale Formation, you didn't hire local, experienced title attorneys to sit in the county records office and pull the physical deed books. That takes too much time, and it costs too much money. Instead, you outsourced your abstracting work to a digital data scraping firm out of Denver. They used optical character recognition software to scan the county's digital database. But our county database only goes back to 1968. Anything recorded before that sits in the basement of this building, bound in leather covers, written in iron gall ink. Arthur pointed a calloused finger toward the floor beneath their feet. If your digital landman had walked down 22 steps into the archives and pulled Deed Book Volume 4, page 312, they would have found Silas Vance's non-severance covenant. It is an absolute restriction on alienation. It runs with the land. It means that when my grandfather sold off the eastern parcels to the Henderson and Gidley families back in the 20s, he sold them the surface, and he sold them the right to collect royalties, but he legally withheld the executive right to lease those minerals to an outside corporation without the Blackwood Ranch surface owner signing off on the contract. Judge Higgins was already turning the pages of the 1922 deed. She pulled a heavy magnifying glass from her desk drawer, leaning forward to inspect the handwritten clerk's notation and the raised state seal. The courtroom was so quiet that the rhythmic ticking of the wall clock sounded like a sledgehammer hitting an anvil. Mr. Henderson, Judge Higgins said, her voice dropping into a register that made Marcus flinch. This covenant is explicit. It states that the executive leasing rights for the entire 12,000-acre original block remain anchored to the homestead parcel, which is currently held by Arthur Vance. If this deed is valid, the oil and gas leases your client signed with the neighboring landowners are legally non-binding. You have executed millions of dollars in drilling contracts based on void title. Your Honor, Henderson stammered, his polished voice cracking as he forced himself to his feet. This is an ancient property restriction that violates modern public policy regarding resource development. The state's forced pooling statutes were enacted specifically to prevent these types of archaic, century-old covenants from paralyzing industrial progress and depriving the state of vital energy revenue. Even if the covenant exists, it has effectively been extinguished by 50 years of regulatory precedent. Regulatory agencies don't have the constitutional power to rewrite private property deeds, Mr. Henderson, Arthur countered instantly, his voice sharp and unyielding. The Supreme Court of this state ruled on this exact issue in Vance v. Chevron back in 1991. A covenant that protects the ecological integrity of a surface estate by restricting subsurface development is an absolute property right. It cannot be stripped away by an administrative board just because a corporation wants to pad its quarterly earnings report. Arthur walked back to his table and picked up his water glass, taking a slow, deliberate sip. The absolute control he held over the room was total. He had completely flipped the power dynamic. He was no longer a bankrupt rancher begging for mercy, he was the landlord, and Vanguard was the intruder caught with its hands in his pockets. Now, let's talk about that bank foreclosure Marcus was so eager to remind me about, Arthur said, turning his gaze back to his nephew. Vanguard spent $200,000 buying up my outstanding short-term equipment notes from the local agricultural bank. You did it through a shell company called Red River Holdings LLC. Thinking I wouldn't track the corporate registration back to your corporate headquarters in Houston. You figured that if you foreclosed on my cattle and my tractors, I'd be forced to sign your master lease agreement just to keep the roof over my head. Arthur reached into the accordion file one last time and pulled out a certified bank check. The paper was crisp, clean, and bore the distinctive blue watermark of the Federal Reserve. This morning at 8:30, when the county clerk's office opened, I deposited $3.2 million into an escrow account held by the court, Arthur announced, placing a copy of the deposit receipt on the clerk's desk. That money completely liquidates every single tax lien, every equipment note, and every outstanding debt held against the Blackwood Ranch. The ranch isn't in default anymore, Marcus. It's entirely debt-free. And do you want to know where that money came from? Marcus couldn't answer. He just stared at the check, his mind racing, trying to calculate how a man who couldn't afford diesel fuel last week was suddenly handling millions of dollars in liquid cash. It came from your primary competitor, Horizon Exploration, Arthur said, a thin, rare smile finally appearing on his weathered face. While you were busy tracking my bank accounts and waiting for me to break, I was talking to Horizon's legal department. I showed them your unedited drilling logs. I showed them the 1922 deed. They realized that Vanguard had accidentally drilled its star production well inside a mineral block that couldn't legally be leased to anyone but them. Horizon paid me a $3 million signing bonus yesterday afternoon for an option to lease the true, legal executive rights to the Alpine shale block. They didn't buy me out, they financed my defense. The revelation of Horizon Exploration's involvement hit the Vanguard legal team like a physical blow. Henderson sank back into his chair, his eyes fixed on the blue watermark of the court escrow receipt. The entire corporate architecture they had built to crush Arthur Vance, the strategic delays, the manufactured credit crunch, the predatory acquisition of his private debt, had not only failed, but had been turned into the very engine of their destruction. Your Honor, Henderson began, his voice stripped of its theatrical resonance, replaced by the raw panic of a corporate attorney facing an imminent malpractice suit. This completely changes the scope of these proceedings. If Horizon Exploration has entered into an option agreement based on a disputed title chain, they are an indispensable party to this matter. We must request an immediate stay of all administrative actions until a formal quiet title lawsuit can be adjudicated in federal district court. There is nothing to dispute, Mr. Henderson, Judge Higgins said, her gavel descending with a finality that echoed like a gunshot through the small room. The title isn't quiet, it is crystal clear. The 1922 deed is a matter of public record, properly recorded and sealed. Your client's failure to conduct basic due diligence before operating heavy industrial machinery across property lines does not constitute a legal dispute. It constitutes gross negligence. The judge turned her attention back to her ledger, her pen scratching across the formal order sheet with aggressive precision. This board finds that Vanguard Energy's petition for forced pooling is fundamentally defective. As the petitioner does not hold valid leases for the required statutory percentage of the drilling block. The petition is dismissed with prejudice. Furthermore, based on the certified directional telemetry entered as Exhibit B. This court is referring this matter to the State Railroad Commission and the Attorney General's Environmental Protection Division for immediate investigation into unlawful subsurface conversion and regulatory fraud. Judge Higgins looked up, her eyes locking on to Marcus Vance, who sat frozen at the table. And as for the allegations of willful concealment of evidence by a licensed landman, this record will be forwarded directly to the State Licensing Board for immediate disciplinary review. This hearing is adjourned. As the judge rose and exited the chamber, the room erupted into a flurry of hushed, panicked movement. Henderson was already on his phone, his voice hushed and urgent as he tried to explain to Vanguard's executive VP why their flagship well in the Alpine Shale Formation was about to be locked down by a state injunction. The junior analyst was packing his laptop with trembling hands, eager to escape the fallout of a multi-million-dollar disaster. Arthur Vance didn't move quickly. He slowly gathered his documents, sliding them back into the worn accordion folder, and snapped the thick rubber band back around the cardboard. He looked entirely unchanged by the last hour, his face remained a mask of quiet, weathered resilience, the face of a man who measured time in cattle generations rather than quarterly financial reports. Marcus walked over to the defense table, his tailored suit now looking completely out of place against the stark reality of the room. "Uncle Arthur," he said, his voice raw, devoid of the smug confidence he had carried into the courthouse that morning. You You ruined us. If Horizon takes the lease and shuts down Alpine Alpha, Vanguard is going to lose $60 million in infrastructure. My career is over. They're going to blame me for the title oversight. Arthur stood up, adjusting his canvas jacket. He looked down at his nephew, his eyes reflecting a deep, sorrowful clarity. I didn't ruin you, Marcus. Your own arrogance did. You thought because I worked with my hands, because I had mud on my boots and debt on my ledger, that I didn't know how to read the system that built this country. You forgot that this land was bought with sweat and protected by law long before your corporation ever put a line on a spreadsheet. Arthur picked up his accordion file, tucking it firmly under his arm. You came here today to take the last thing my father left me, using a legal system you thought belonged only to the rich. But the law doesn't belong to the man with the most money, Marcus. It belongs to the man who keeps his word, keeps his records, and knows exactly when to stand his ground. Without waiting for a reply, Arthur turned and walked toward the heavy oak doors of the courtroom. As he stepped out into the bright West Texas sunlight, the dust on his boots looked exactly like it had that morning, but the land beneath them was completely, undeniably his. The afternoon heat radiated off the courthouse concrete as Arthur Vance walked down the wide limestone steps. The town of Alpine was quiet, its wide streets shimmering under the expanse of the Texas sky. Behind him, inside the building, the corporate machine was still spinning out of control. Phones were ringing in Houston, legal strategy meetings were being called in Midland, and an entire board of directors was discovering that their high-yield energy asset had just become a catastrophic liability. For the corporate elites, the Blackwood Ranch had been a math problem, a sequence of acres, depths, and shale yields that could be optimized, leveraged, and ultimately stolen. They had quantified everything except the one variable that mattered, the memory of the people who settled it. They didn't understand that a man who has spent 70 years watching the weather, repairing fences, and pulling calves out of the frozen dirt develops a different kind of intelligence. It is an intelligence rooted in patience, observation, and an absolute lack of fear. 2 weeks later, the State Commission officially issued a cease and desist order on the Alpine Alpha No. 3 well. The pumps stopped. The roaring diesel engines that had echoed across Arthur's eastern boundary line for months fell completely silent, replaced once again by the natural cadence of the wind through the scrub oak. Vanguard Energy eventually settled out of court, paying the Blackwood estate the full gross proceeds of the converted oil alongside a massive structural easement penalty just to avoid a public criminal trial for fraud. Marcus Vance left the energy sector entirely, his reputation among regional landmen permanently shattered by the digital signature he thought he could delete. Arthur used a fraction of the settlement money to replace his old Ford F-150 with a sensible, modern model, but the rest of the capital remained in the court escrow account, untouched. He didn't buy a mansion in Dallas, and he didn't invest in tech stocks. Instead, he hired a local fencing crew to run a new, heavy-gauge steel boundary line along his eastern border, not to keep people out, but to remind anyone who looked that the property rights of the Blackwood Ranch extended from the highest point of the sky straight down to the center of the earth. On a warm evening in late June, Arthur stood by the newly reinforced gate, watching his cattle move slowly toward the water tanks. The ranch was debt-free, secure, and legally unassailable for the next 3 generations. To the executives in Houston, he would always be the broke rancher who somehow broke the system. But as Arthur looked out over the sweeping, golden horizon of his land, he knew the truth. The system hadn't saved him. He had simply used their own arrogant rules to remind them that some things cannot be bought, some men cannot be broken, and the dirt beneath a man's boots is worth nothing if he isn't willing to fight for it.